Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Today, we're going to talk about the intersection between intellectual property, particularly copyright law, and residential building development. This is the case of Carlisle and TIC. Right. Carlisle is an established high-volume residential builder. And over the years, Carlisle is involved in the sort of developments you might imagine: designing homes, getting things ready, then selling them, passing them on to a vendor for them to be sold, and going on to the next block of land, going on to designing the next estate, going on to selling the next set of homes. TIC is something of a new upstart, hoping to become the next Carlisle, if we can put it that way, hoping to become another established high-volume residential builder. Now, some of the designs that Carlisle uses for its homes are eerily similar to the designs that TIC is using for its homes. And what Carlisle decides to do is commence proceedings against TIC, suing them for copyright infringement in respect of those designs. So those proceedings are on foot. What Carlisle then decides to do is to seek an immediate injunction, saying, not only are we commencing proceedings for copyright infringement, but we want an injunction, a stop right now on TIC putting any of the contested designs to use at all. It ends right now. So can I have that distinction clear in your head? There's one broad claim where Carlisle is looking to succeed at the end of copyright infringement litigation. And as that's going on, Carlisle's also making an application for an immediate injunction right now. Good? Got it. To get an immediate injunction, what you need to do is you need to establish that if the matter goes to final hearing, you've got a strong case, and you need to be able to establish that the balance of convenience is met in relation to the relief. Essentially, you have to prove that damages are not good enough, such as the damage being done. You need an injunction because damages won't be enough. Now, what the court did was take a look at the evidence relating to the contested designs and form the view that they were pretty similar, that they were prepared by TIC in a surprisingly short amount of time, that an employee who had jumped ship from Carlisle onto TIC couldn't really rule out that he'd subconsciously had the Carlisle designs in mind when the TIC ones were being put together. So it appeared that there was a reasonable view about the prima facie case there. So the next question was the balance of convenience test. Are damages enough? The court found no. The court said TIC is a newcomer to the industry. The court said TIC has a financial backer that will be able to pay any damages bill that flows from the copyright infringement. And TIC said that the amount of damage that would be done, the court said that the amount of damages that would be done to TIC if the injunction was granted would be such that the balance of convenience favours not granting the injunction. So the court ordered no injunction, which means that the court ordered TIC to pay Carlisle's costs, because remember, Carlisle failed to get an injunction, and the court then ordered, perhaps a common sense one, to bring the substantive proceedings on for final hearing as soon as possible. So I hope today's quick chat and quick coffee assists you in understanding the difficulties that parties can face when looking for an interlocutory injunction, and also the interplay between copyright, which is sometimes thought of a bit of an ephemeral kind of an area, and real world rubber hitting the road business and commercial work. Thanks very much. I look forward to joining you for another coffee and another case note soon. Cheers.